So I'm here with Sheena, and Sheena is going to ask questions to discuss council tax, and we're going to look at whether the council tax has jurisdiction. The magistrates or county courts have jurisdiction over us to pay council tax. I'll let you.
Right. The council do not print liability orders. They print off a mere notice of a liability order instead. A notice is just a notice, not a liability order. Magistrates Court Act 1980, Section 58, and the County Court Act 1984, Section 16, appears to say that the liability orders cannot be enforced in the county court because this court does not have the jurisdiction, and liability orders can only be recoverable summarily. So why are they taking people for charging orders, bankruptcy orders in the county court? Magistrates Court Act 1980, Section 58, money recoverable summarily as a civil debt. 1. A magistrates court shall have the power to make an order on complaint for the payment of any money recoverable summarily as a civil debt. That means it's not a fine. The County Court Act 1984, Section 16 says money recoverable by statute. The county court shall have the jurisdiction to hear and determine an action for the recovery of a sum recoverable by virtue of any enactment for the time being in force, if, and it means an only if, A, it is not provided that by that or any other enactment that such a sum shall only be recoverable in the High Court or shall only be recoverable summarily, which means, if you read it backwards, that the county court does not have the jurisdiction to hear sums that are recoverable summarily that are carried out in the magistrates court. The Council Tax Administration Enforcement Regulation, Section 3, says the amount in respect to which a liability order is made is enforceable in accordance with this part, and accordingly, for the purposes of any of the provisions of Part 3 of the Magistrates Court Act 1980, satisfaction and enforcement is not to be treated as a sum to be paid by order of the court. That means it's not to be treated as a criminal fine.
So can we go back to County Court Act 1984? What does it mean by shall only be recoverable summarily?
It means that basically the county court cannot hear sums that shall only be recoverable summarily, which is exactly what it says in the Magistrates Court Act. The money can only be recoverable summarily as a civil debt. So the county court does not have the jurisdiction to recover sums that are recoverable summarily from the Magistrates Court Act. So why are they bringing in applications for interim charging orders, bankruptcy, without it going back to the Magistrates Court? Because they're the only ones that have the jurisdiction to hear it. The county court doesn't, according to that. Now, if anybody knows anything different, I'd like them to put it up to prove otherwise, because they've written it backwards. So it is not provided. So if it was provided, they could hear it, but they can't hear anything from that's expressly recoverable in a High Court or shall only be recoverable summarily as a civil debt. And this is a civil debt. It's not a fine. County courts only deal with civil. So that's what that means.
Right.
And it takes a little bit of going over, but as far as I'm aware, that's exactly what it says. They haven't got the right to recover sums that can only be recoverable summarily.
So the county court has no jurisdiction?
Has no jurisdiction over liability orders. So why are they pretending to have a liability order that they would never produce to get charging orders on people's houses, possession orders, bankruptcies? They shouldn't be doing it in the county court.
So what they're saying from the statement above is that Magistrates Court and the county court, they're saying that liability orders, who creates the liability orders?
The liability orders are created in the Magistrates Court as a civil debt. It's not a fine. So because it's not a fine, this would be a fine if it was treated differently. It's recoverable summarily as a civil debt.
Right.
So if it's recoverable summarily as a civil debt, the County Court Act says the County Court does not have the jurisdiction to claim to do these, or shall only be recoverable summarily, because it is only recoverable summarily as a civil debt. And that tells you in the County Court Act that they haven't got the jurisdiction to hear it. That's why they do the liability orders in the Magistrates' Court,
Right.
not the County Court.
So
So
if
they
they
shouldn't be
create-
enforcing it in the County Court.
And are the county courts enforcing it?
Yeah, they're using these so-called liability orders that they would never produce to put charging orders on people's houses, to get possession orders, and to do bankruptcies. And even in the County Court does not have the jurisdiction to do bankruptcies because they have to have specially ticketed judges to hear these. So how they get round it is they pretend that you've consented when you have not. So the County Court should have nothing to do with sums that can only be recoverable summarily, which is a civil debt that occurs in the Magistrates' Court. And the liability order is a civil debt. That's why they won't produce the liability orders. Because if they had them, why not just produce them? What are they using as proof in the County Court? Fresh air. When you ask for it,
There isn't.
nothing's produced.
Well, the magistrates or the magistrates' courts will say that your liability lies under the Local Government Finance Act. Is it 1992?
Yeah, that would be under the, what's that? No, not that one. That's under protection. Yeah, they will. But at the end of the day, this says otherwise. This says they don't have it. The County Court Act says they cannot recover it by statute because it's recoverable summarily.
What does summarily mean?
It's a civil debt.
That's it.
Recovered, as far as I'm aware, recoverable summarily as a civil debt because it's not a fine. So if you look in the Magistrates' Court Act, you'll see there's fines and you will see there's civil debt. So if it's a civil debt, if we had a civil debt, we'd have to go straight to the County Court. Why the County Court? Why the councils go into the Magistrates' Court to get a liability order, knowing that the County Court hasn't got this jurisdiction according to the County Court Act of 1984. If I'm wrong, I'd like somebody to
Point it
out because this says clearly they can't do High Court if it can only be recoverable in High Court, and they cannot do sums that are recoverable summarily. And it clearly is a summarily. It's clearly a civil debt as a summarily civil debt. So what else can it be? So although they say, oh, we can do this, that and the other, it tells you here, Council Tax Remuneration Enforcement Act, not be treated as a sum to be paid by the order of the court. That means it's not a crime. There you go. In accordance with the purpose of any provisions of Part 3 of the Magistrates' Court 1980, that one, satisfaction enforcement is not to be treated as a sum a judge to be paid by the order of the court because it's not a fine. So if you had a fine, a criminal fine, they could come after you. They could enforce it, but they couldn't enforce it in the county court. But they could come after you with a criminal fine, but they can't come after you for a civil debt according to this County Court Act 1984.
So this is how they put in CCJs on people.
Well, then, yeah, exactly. Well, they're not actually producing a CCJ. They're not producing any evidence in a county court. There's no liability order produced. You can ask till you're blue in the face, and the most you might get is a copy of a complaints list, but you're not going to get a liability order. So what are they basing their charging orders on? What are they basing their bankruptcy orders on? If they've got nothing, because it shouldn't be. And if you had a bankruptcy, it has to be sent back to the Magistrates' Court as returned whole and in part. Nothing's getting returned to the Magistrates' Court whole and in part. So all they're doing is conning you, I think, into going into the county court when they haven't got the jurisdiction. Because if they had the jurisdiction here, it wouldn't say, or shall only be recovered summarily. That wouldn't be there. It would just say, oh, the High Court, they can't do it. It wouldn't say only be recoverable summarily.
Okay.
And a magistrate's one can only be recoverable summarily because it doesn't have it. There's no other way they can do it. There's either a civil debt or there's a criminal fine. Both owe money, but two sides. So there's only two jurisdictions. The civil one is beyond reasonable doubt. The criminal one's beyond reasonable doubt. The civil debt is on the balance of probabilities. So this should stay in a magistrate's court because the county court doesn't have the jurisdiction. How can they give it jurisdiction it doesn't have, is what I'm asking. Because if they had it, that would be missing, or only should be recoverable summarily. So it's like they write things backwards. So you think, oh, well, they can do it, because if you read that as it is provided by any other enactment that such a sum can be recoverable, you'd go, okay, that's okay. But it says it is not provided. Well, it's provided in this Act that it can, on complaint for payment of money, recoverable summarily as a civil debt. So there it's clear. It is recoverable as a civil debt. It means they can't do it. If they can do it there, they can't do it there. Can you see?
Yep.
That's where it looks, but it's really just two things: fines and civil debt.
And they've actually put people in prison for not paying council tax.
I think they have. I don't know, but basically, I'm wondering how they're enforcing these things in a county court. If the counts were the jurisdiction in the county court, why not just go straight to the county court? Why bother with the magistrate's court to then bump it up to the county court if they don't need to? Because we don't go to the magistrate's court to enforce a debt.
How often do you know of a council tax debt being bumped up to the county court?
Well, everybody that's got interim orders, final charging orders, possession orders, all based on the back of these liability orders that they won't produce. Bankruptcies.
So it seems to me that what the county court is dealing with is the interim orders, bankruptcy and whatever, not the actual liability.
No, but they're basing it on a liability order that can only be recoverable summarily.
Right, so they're avoiding
providing any proof.
Providing proof of the liability in the county court.
Yep.
Once the magistrates' courts have issued CCJs or...
The magistrates don't issue CCJs. CCJs are county court judgments, but the magistrates are saying that they produce liability orders. Well, they don't. They just have a complaint and they sign a complaint. But what they're trying to say is that the liability order there that they got from the magistrates' court, which they can't produce and they never do produce it, as evidence is used to create a charging order or a bankruptcy or possession order. Well, where's the evidence and why are they using the county court to do that when it says that they can't?
Right, so if you go to a county court to argue this, they won't touch on the liability.
No.
They will only touch on what the county court has asked them to issue, which is a CCJ or bankruptcy or whatever.
Yeah,
but you can't argue the liability.
No.
They'll tell you to argue that you need to go back to the magistrates' court.
Well, you can't get a liability order out the magistrates' court or go there. We've tried. You can't even get your court cases. You can't get nothing.
You can't, because they won't hear it, because in a magistrates' court, the only thing they can hear is why you haven't paid.
Exactly. But it also says they can only be recoverable summarily. So if it's only summarily, it's clear, according to this, that it's the magistrates' court that should be enforcing these, not the county court. Because the county court doesn't have the jurisdiction to hear sums that should only be recoverable summarily.
Okay.
So it's like if it was in the High Court, they clearly can't do anything that's only recoverable in the High Court.
Right.
So if they couldn't do it in the High Court, then if they could do it in the High Court, they wouldn't be allowed to do it in the County Court. If they could do it in the Magistrates' Court, they wouldn't be allowed to do it in the County Court for recoverable summarily, because it says so. So there's something adrift.
So, and the council tax administration and enforcement regulations.
Yeah, that's just telling you there that it's not to be treated as a sum adjudged to be paid by the order of the court. Why? Because it's not a fine. That's why it's not to be treated as a sum, a judge to be paid by the order of the court, because the sum adjudged would be for a fine. So if you was done a criminal offence and you got a fine, then it would be adjudged as a sum to be paid by the order of the court. But because it's not a fine and it's civil, it is not to be treated as. It's where they put the not to be, the ifs.
Right.
So basically, if people read this and see what they make of it, because it doesn't make sense that they are jumping from a magistrate's court straight to a county court when it says here they can't. Because it's a summarily recoverable sum. It tells you there, money recoverable summarily as a civil debt. Well, that's all they can do.
Okay. And is there anything else that you want?
It was just basically telling you about the national debt line. Says that you cannot be asked to pay council tax if you're not named on the bill. I wasn't named on the bill.
Right.
However, if a joint tenant or joint owner or member of a couple is not named on the bill, the council can send out another bill, adding their names. Only if they've got the names. Once the council's done this, they can ask anyone named on the bill to pay. I wasn't on the bill.
Yeah.
What they do is they just ignore that. They won't tell you where they got your data from, which they must do under the Data Protection Act and the GDPR. So what they do is they just literally took my partner's name off and put mine on so they could bankrupt me. But they can't do that. If he'd have given my name or he'd asked them to, that would be different. But it wasn't in the joint name. They just
assumed you were here.
They just assumed whatever they wanted to assume. But the council should tell you where they got the data from. The MP won't even ask the council to provide where they got the data from and why they changed funds. Because they don't just do this. They move funds so that then they can bankrupt you. It's all fraud. And that's exactly what they're doing. A few other things is important. Statements of truth. It's important. There's a practice direction called Statements of Truth, and it tells you documents must now be verified by statement of truth. What that means is if I say something is true in a statement, I have to swear to the facts as a statement of truth in addition. And you'll find that a lot of these things are not being filed correctly. There is no statements of truth, or they're not sealing the applications into the county court, or they're not dating them. You won't get case files. You'll get nothing. And they should be served on you. Service is important. They're not serving nothing, really. Other things are the MOG Regulation of Enforcement Agents' Response to Consultation, 18th of March 2008, protection of title. Only those people that meet the requirements agreed by the council will be able to call themselves registered bailiffs or registered enforcement agents, because that's what they're called now, and use procedure in Schedule 12. So if they were just doing this for goods or possessions, the title and activity would thus be protected, and those found to be acting outside the code of conduct to be a requirement for all registrants could and would be removed from the register. Anyone not qualified, like the people that come through the door, won't even produce SIA licences or SIA badges or their name, to act in this way would be committing a criminal offence. This is what it says on there if you look this up. Thus the public would be protected from the unscrupulous practitioner, and practitioners will be able to demonstrate accountability and good conduct. Yeah, good luck with that one. So rogue bailiffs and police who do not know or uphold the law and are acting lawlessly outside of their remit and office are to be treated as intruders. This is quite an important one. CPS Self-Defence and Prevention of Crime. Section 76 of the Criminal Justice and Immigration Act, 2008. They often put these like this so you ignore this. The law on self-defence arises both under the common law defence of self-defence and defence is provided by Section 3.1 of the Criminal Law Act 1967, the use of force in the prevention of crime or making arrest. It's recently been clarified by Section 76 of the Criminal Justice and Immigration Act 2008. Subsection 5A allows householders to use disproportionate force when defending themselves. Disproportionate, it means more than normal force. against intruders into their home. In deciding whether the force might be regarded as disproportionate or grossly disproportionate, so one might be giving them a good slap, the other one might be shooting them. The court would need to consider the individual facts in each case, including the personal circumstances of the householder and the threat, real or perceived. You're at threat if they're at your door, posed by the offender. You can look it up on that. Criminal Attempts Act, I can't remember what I put for that. And then there's just a couple of bits. The County Court Act section, remember County Court Act up there? 135 and 136. 135 is penalty for falsely pretending to act under the authority of the court. Well, how can they act under the authority of the court if it hasn't got any? 136, penalty or falsely representing document to have been issued from the county court. Are they coming from the county court? Where's the applications that are sealed? Why aren't we being served with these applications? And then the sweetener on the cake is Equal Treatment Bench Book. I haven't put the link, but you can look it up. This is what the judges are supposed to do and what they're supposed to take into account. They might as well rip it up and put it in the bin because they don't follow any of it.
You mentioned in our conversation briefly that the bailiffs are registered as what was the
They should be on the certificated bailiff enforcement agent register.
But they create a company.
Now this is for the High Court.
Right.
The High Court Enforcement Officers, I haven't written this down, Association. It's High Court Enforcement Association, Officers Association. Now, the certificated bailiffs or the agents are lower. They do all the low stuff. The High Court Enforcement are the ones that the High Court use when they bump things up to the High Court, which they are from the County Court, which they shouldn't be. But what they do is they create a company. I think Court Enforcement Services was one, and then they'll close that, and then a couple of them will open up another company, set up a different firm, and these officers are appointed by the Lord Chancellor. I think they have to, I think it's anything over 6, I'm not sure how much the money is, but it's basically for possessions, for enforcement of possession orders that they bump up to create writs. So when they get these so-called writs, they don't. What they're doing is they're not serving the notice of evictions properly. They might serve something, but it will not all be filled in correctly with the right company. They're not serving a copy of the writ. So what they're doing is they're sending their pals, who are certificated bailiff or agents, to turn up who've got no jurisdiction whatsoever and shouldn't even be in anybody's home. That's what they're doing, but they'll open a company.
And it's a self-regulated.
It's self-regulated. So in other words, they are not regulated by anybody, but they're appointed by the Lord Chancellor. Now the Lord Chancellor says on these so-called writs that he is witnessing them. Well, he can't be witnessing them because they're not coming out of those courts. So I think they're using this to get round what they're doing. So the courts can say, well, we're not committing fraud because we didn't issue these. That's why they'd have no judges' names on them. If there's no judge's name on it, who did it? All the other orders you'll get will be, oh, such and such sat on such and such a day. You shouldn't have to keep checking to see if anybody was actually sat that day or who did the order. But the High Court Enforcement Officers are the problem because they're completely unregulated. They all know each other and they're not doing their job. They're not turning up. You pound to a penny that the High Court Enforcement Officer will send a Joey who will pretend to be one, which we had in 2019. We had no paperwork at all. They might even work for different companies. I believe that they're all getting paid cash in hand. I don't think this is going through the books, any of it. This is the way they get round things, because if you wanted to commit a crime, you're not going to want to do it yourself. So you get your pals to do it.
So the High Court Enforcement Officers Association.
Yeah, they have a register, and all of these High Court Enforcement Officers must be listed on it. Unfortunately, some of them are writing down their companies as trading names. Malcolm Davis, who should have turned up here on the 4th of March, had put down a PO box number. and a trading name. What they do is they'll have a trading name of a company. I think they call it High Court Writ Enforcement, but it's a trading name of another company. And then they'll open up a company with the same name, High Court Writ Enforcement. So who's the trading name for? With the PO box number. And 4 days after, he then became a director of that, a company director of the company, and put his residence down as Spain. So he didn't turn up. So they are employed and approved by the Lord Chancellor, nobody else. They should be held accountable, not self-regulating. There's no association over them that regulates them at all. They're just mafia, as far as I'm concerned, for the high courts to put these fake writs through, to push through. Because if these should not exist without accountability. The certificated bailiffs register, you can complain about them. But these, if you want to complain, and we have, you're only complaining to them. So you're complaining to an association that they're members of. It's self-regulating, nobody above them. And if they're opening all these companies and shutting them, I believe it's just money laundering. And if they are paying anybody, where's the paper trail? Where's the proof that they can assign any of this? They can't assign a writ 66, which is a writ possession, and they cannot assign a writ 68, which is a writ of restitution. So if they can't assign them, it means they've got to turn up. They're not turning up. They're sending a load of thugs who won't provide any SIA badges, that won't even provide their names half the time. Scott Hines refused to produce any ID because he was worried people might know who he was. And he's only a certificated bailiff, or a certificated agent, because they've done away with bailiffs. So he's only a certificated agent. So he had no right to be here in the first place, let alone bring a load of thugs with him, break into our home, and without any evidence, and without even serving the so-called writ that had to have been served with the notice of eviction. The notice of eviction wasn't even filled in properly. So this is what they do. They won't have numbers on them. Things will be missing. And because of this, they're stealing people's properties. What they've got to do, if they have the right to do what they say they're going to do, then do it properly. If not, they shouldn't be allowed to be there. And personally, I think they should all be in prison.
So we've gone from the start of proving there's no liability. They can't prove you the liability. They issue it in a magistrate's court. It's a civil debt. The county court has no jurisdiction over it.
No.
But somehow the magistrate court pushes it onto the county court, where they issue you CCJs, bankruptcy, etc.
The magistrates aren't pushing it. What's happening is you're getting dodgy solicitors pushing it, or the council solicitors, whoever they are, making applications into the county court without providing any liability orders or proof. And because they're not providing that, they just carry on, they steamroll it. So then they'll get a possession order, all on the back of fresh air. And then they'll do bankruptcies, and then they'll bump these possession orders up to the High Court. Not correctly, by the way. No, ours was never bumped up correctly. It was just opened via an EC file, by an email, by Bradley Keith Bloom of J. Barring Limited. And that's what they'll do. And they're not even supposed to do that. But that's what they're doing, and then they send round the thugs.
And then they send round the self-regulated agents.
They don't send round the self-regulated. The self-regulated send round the lower ones who haven't got the jurisdiction to turn up anyway.
Right.
Because the High Court enforcement officer must. That's his job. That's why he's a High Court enforcement officer.
Because if you're a High Court enforcement officer, your badge has to be signed by a court.
You're approved by the Lord Chancellor, where the certificated agent or bailiff is not. That comes from the county court. They get that through a county court certification.
So that's the certificated bailiff register.
Yeah, that's a different register, and that's where they apply to a county court. The difference between the High Court Enforcement Officers Association, which is for High Court Enforcement Officers only, is that they are approved by the Lord Chancellor. The certificated bailiff register are lower. They're agents, they're certificated agents, and they apply to the county court. So they do all of the for goods, if they're going to take people's goods, this, that and the other, that's who would turn up for them.
And they're not allowed to enter into your house?
Not as far as I'm aware, they're not. They've got no more powers than these. None of them can enter into your house unless it's for a criminal debt, which is why it's important, or it's a commercial property. So the certificated bailiff register, these people should not be turning up in place of High Court enforcement officers. They don't have the jurisdiction to turn up, and they shouldn't be hiding their badges, and they should identify, and the police should make them identify, because it's a criminal offence not to show your ID and your SRA badge, as it's stated up here. They shouldn't be turning up at all. Otherwise, it's a criminal offence to turn up, pretend you're something, because it's a qualified title. It's a protection of title. And that was done on the MOJ Regulation Enforcement Agent response on 18th of May 2008. So these people are all criminals if they're turning up pretending to have powers they haven't got.
So we're doing this video now to put this information publicly so that everybody can start looking into this.
Yeah, start looking into it and seeing if their paperwork's correct, to see if they have had proper service, to see if they have had statements of truth in their applications, because we've never had anything done correctly. And solicitors can't just be signing things willy-nilly. And you can't have unqualified people turning up at your house who haven't got the right to be there. So they shouldn't be taking people's homes, especially if the courts haven't got the jurisdiction to do it and are pretending they have. And that's why I believe they're sending out fake writs from the EC file rather than from the court. Because no court judge is putting their name to these. And they should be. If it was a correct writ, it should have the name of the judge on, and he would have had all of the correct applications. The one that Michael Abram Goldstein obtained from the EC file, he didn't even put an application in for it. On the EC file, there's no application. So how could he have a writ that he didn't apply for? But they manage it somehow because they have, I believe, they have people in the offices. In fact, we know that they have people in the offices. We've actually seen evidence of it where we've turned up and they've been notified, the solicitors have been notified that we were there when they shouldn't have been because it's an ex parte hearing. So all I want is people to look at all of this and add to it. Is there anything they can add? Is there anything there's things incorrect? Is there any evidence that any of this is incorrect? That's all we want. We need people to start looking into it, looking at their documents, sharing their documents, so that everyone can see what's gone on. And if you have had anything done correctly, then you would have everything. It would all be there. We'd be able to see the documents and say, okay, yeah, yours was done correctly. But I think in most cases they're not done correctly. No.
Yeah.
And I think that's why these judges, the High Court, the Royal Courts of Justice, the High Court, which has two divisions, Chancery and Queen's Bench, are both ignoring it. They're both ignoring the fact that these are not coming from the Lord Chancellor as a witness. That's the Queen's Bench or the King's Bench. And the Chancery division are just ignoring it because they've already confirmed to us that the Insolvency and Companies Court didn't do writ 66s or 68s. And I want everybody to check.
So what about if someone was to argue that they do have the liability under the 1992 Local Government Finance Act?
Well, then they can point out why the County Court Act says that they can't hear a sum that can only be recoverable summarily.
Right.
It can't be both. They've either got it or they haven't. So it's either that one's incorrect or this one's incorrect. And I don't believe that they have the jurisdiction simply because they never, ever, that I've found, put you in front of a judge who's got the jurisdiction, or they trick you into pretending you've consented to something, and their paperwork's never correct. So if the paperwork's never correct, why not? They can't all be incompetent. So if they had it, why not just prove it? Well, why are they making people that are not named on the bill pay
Yep.
and flicking it from one to the other?
Yep.
Because it suits them. No, it should be transparent. They should have you agreed to pay to this or not, or everybody has to pay for this. They wouldn't make it so complicated so that you haven't got a clue what's going on and you've got to track all of these acts to find out. It should be straightforward process, start to finish, that everybody understands. And nobody understands it. They've made it so complicated, and it's a case of, well, you'll just do it because we say so. But when we saw them blocking that court doors to the magistrates' court, and we saw that the council officers just stood there thinking they could just bully you and pretend they were a court in a corridor when they're not, that's all wrong. Because if they had the jurisdiction, they would do it properly. And if they're not doing it properly, it's obvious they're either incompetent or they haven't got the jurisdiction. And I think it's the latter.
In fact, the courts have actually admitted that the council tax has nothing to do with them, that they are a separate. The council hire the rooms.
I don't know if they hire them. All I know is that the council officers turn up and they pretend that you're having a pre-paper hearing.
Right.
When you're not. There's no such thing. And we pointed that out to them. And that's why we ended up going down that route, because we were told that the court staff was there and they were basically just bullying. And these councils make thousands and thousands. You know, it could be like 30, 40, 50, 60, 70, 80,000 off the people that can't afford it through the costs. So it's a money maker. And I think, but I can't be sure, that the courts get paid something like £1.50 for each of the summonses or whatever they issue. But then when they say that the courts don't issue the summons, the councils can issue the summons if the magistrates have agreed. But just because you've issued the summons, just because you've done all this, can they enforce these liability orders? I don't think they can.
Right. Okay. Thank you for this. And if anyone has any questions or anything they'd like to add, but I think this is great for people to start asking some very important questions. And there's sites here as well which you can go and click on. Not click on, but, research yourself. Thank you.